Floor's mine, or?
Yeah, who wants to start off?
All right. So this is Tom Isenbarger. I am a patent attorney at Casimir Jones in Madison, Wisconsin, along with Dave Casimir. And we are helping with the with Porta Sophia, which is what I'll be introducing today. And then I'll talk for a bit and then hand it off to Shaheen, who's out in California. She'll chat a little bit, and then Dave will finish up. Some of this is similar to what I presented to the Psychedelic Law Summit a few weeks ago. My hope is that this will touch on some of the same things, but allow us to go a little deeper, since this is the IP committee and not such a broad range of lawyers, and provide maybe a little bit more depth of what we do and more time for questions if we need it. Yeah, so next slide, please. So brief structure of the talk, talk about why we started this nonprofit, this project, and then what we do, and then sort of at the end, how we have had some direct impacts on the patent landscape and the psychedelic patent world. Next slide, please. I think, being in the IP space, these types of headlines are not new to us. We understand that there's been a lot of attention in the media about psychedelics. There's been a lot of attention from the investment world, from the research and medical world. It's definitely entered back into the sort of the media, and people are starting to see these headlines and talk about it, and there's definitely interest being increasing. Next slide, please. And here are just a few more specifics on this. We know that there are several clinical trials with various psychedelics happening in the U.S. and around the world. Some of them are very mature and are sort of taking next steps along the trial pipeline. Some numbers here providing rough estimates of the market value for what this technological space looks like. It's in the billions of dollars, and the number of companies that are being involved in the psychedelic medicine world are just increasing. And then as what was touched on quite a bit in the Psychedelic Law Summit, there are efforts to decriminalize psychedelic drugs around the country, and with various strategies and various frameworks for doing that. There are others that are part of the PBA that know more about this than I do, but definitely, there are efforts ongoing in different ways, in different places, that will certainly impact how the IP landscape develops along with that. Next slide, please. We're frozen.
Well, maybe to start discussing it, we'll see if it changes. It's the next one is the graph on the number of overly broad.
Yeah,
there we go.
So
sorry,
this is
back here.
Okay. This is a bit of data we collected from looking at patent applications in the US that had filed with subject matter relating to psychedelics. This, I believe, is accounting for about 5 different chemicals, different compounds, including psilocybin, DMT, 5-MeO DMT, probably mescaline. I forget what the other ones are. And then we've taken of those compounds and those patent applications. This is showing the numbers of sort of by some of our metrics, which are egregious. They have claims that are overly broad or look like ones that could be problematic for the psychedelic space. By any rate, it's definitely showing an upward trend that is taking an exponential leap from about 2017 through 2021. We have incomplete data now for 2022 because we haven't, seen all the publications, but I would expect that trend to continue. In the pie charts, there are just some breakdowns by what types of claims we're seeing and who's applying. Probably, just to give you a little feel, taste for the landscape there. Next slide, please. So, given that, it sort of brings us to, there's a lot of interest in the world, in various realms of the world right now. What was the problem we were looking to address? And it has to do with, in the patent world, a lot of the relevant prior art is different than what patent examiners are used to seeing, and that is prior art that comes from peer-reviewed journals or other patent applications primarily. There are sources of prior art that are based on anecdotal stories of indigenous use, the sort of classic research from 100 years ago through the beginning of the drug war, and archival materials from individuals who kept notebooks, things like this that is important for establishing and providing evidence for what is in the prior art, what has been done before, what was known, and that may be difficult to find. So that was the problem that we saw, and so what we wanted to do is try to make that prior art easier to find and use for those who are stakeholders in this process, be they patent examiners, investors who want to kick the tires on a technology to see if it's worth investing in, inventors who might want to know patentability before they enter into the sort of patent pipeline. Anyone who might want to know, prior art landscape. Next slide, please. And I think as we know in the IP world here, that if the relevant prior art isn't provided, there can be problems with the claims that are issued that haven't been subject to that prior art. You see overly broad claims that then can touch on what was public domain, what is public domain, could possibly prevent research from happening that is based on what has been known. There are inefficiencies in the market that cause price changes in drugs. All kinds of issues with not providing the evidence that is needed for a proper examination of patent claims. So, as I said, that's the mission here for Porta Sophia, is to make that prior art easier to find and use in patent examination. With that, I think I'll introduce Shaheen, who will take it from here.
Got it. Hello, everyone. My name is Shaheen Shams, and I'm a Ph.D. candidate at UC Davis in biomedical engineering with a designated emphasis in biotechnology, and I am also a data curator here at Porta Sophia. And I'm going to talk a little bit more about our workflow, so how we actually make this happen. So first and foremost, we track psychedelic patents and applications through patent search engines, identifying applications and granted patents that refer to 33 compounds on our shortlist that are of psychedelic or hallucinogenic origin. We then evaluate those patents and sort them into a 3-tier system I'm going to go into that a little bit more a little bit later, but briefly, we'll take a look at the overall breadth of the claims, and if it contains information that is relevant to the public domain. We take a look at the applicant's history as to whether they have a history of filing overly broad applications in the past, or whether the data that is included within this particular filing does support the scope of claims presented. And then if those claims are granted, what sort of threat that poses to research and innovation in this space. We then identify specific patent categories, so whether it refers to a method of treatment, production, derivative compound, drug combinations, or delivery and formulation aspects, and curate patent themes in order to identify prior art. So taking a look at the specific compound, indication, synthesis method, drug combinations, dosage range, etc. And if the time frame is right, we also consider for the tier 1 patents, so as opposed to largest threat to the public domain, whether we want to file a third-party intervention in the form of a third-party submission or a third-party observation. We then locate and curate prior art, first doing a general web page search for other patent documents, scientific journal articles, books, websites, public forums, etc. Then have a second step of going through some archival sources as well and kind of leveraging history in that aspect. We then curate this prior art, locating keywords, quotes, and summaries, and put that on the Porta Sophia prior art library, where we don't only have the tier 1 to 3 patents and applications, but also the prior art that is relevant to these modern patent themes. So from this workflow, we've developed a two-prong approach. First one being more passive in nature, and that is building our psychedelic prior art library that is available to all. And the second is actually directly leveraging this prior art and getting it directly in front of the examiners through third-party submissions and observations. So taking a look at prong 1 a little bit closer, we are a simple search tool for psychedelic prior art. We contain specially curated summaries and descriptions of psychedelic prior art from a broad variety of sources. There are also easy methods for refining results by date, prior art type, focus area, and even screening for additional compounds and keywords. And the search terms are highlighted within the curation for ease of identification. And what sets us apart as well is that we want to leverage historical knowledge in order to shape the present through our archival researcher network, which is an international network of historians and archivists specializing in psychedelics. Essentially, we're crowdsourcing archival prior art based on patent-derived targets, which expands our prior art library with unique historical documentation relevant to modern patenting. So next, we're going to take a look at our second prong, so more of our direct approach. And for that, we need to give a little bit more in-depth analysis of our 3-tier system. So the first tier is that is the biggest threat to the public domain. So applications and patents that fall within this tier contain claims that already have information that is within the public domain. So it's already established in prior art, has multiple overly broad claims or prophetic claims without data domain, and therefore has potential to block innovation in this field. The data that is included either is very limited in nature and does not support the scope of those claims, and the applicant may have already filed overly broad patent applications in the past. Tier 2 is those that are a little bit more focused in nature, not as broad in scope. So it's focused on a specific compound for a specific medical indication. The claims that are referenced may have had some of the information already established in prior art. It could be potentially relevant to the psychedelic field, but it has a low potential to block innovation in this case. The data that is included does support the scope of the claims, and the applicant likely has not filed multiple overly broad patents or applications. And finally, we have tier 3, which is generally off topic for very narrow claims regarding psychedelic compounds. It doesn't fall within the 5 relevant patent types that we're searching for. The patent application is not going to be a barrier for entry for others that want to participate in this field, and the data supports what is claimed. And again, the applicant likely has not filed multiple overly broad patents or applications in this space. So we began participating in these direct intervention strategies late last year. Domestically, we have filed 9 third-party submissions, ranging from a variety of psychedelic drugs and also focusing on a variety of different medical indications, against patent applicants and assignees from broad cross-section of what we had previously presented. So we're looking at private companies, public and private universities, and even government agencies. And we have also participated in international interventions as well, third-party observations, both at the UK as well as at the level of the World Intellectual Property Office. So we're going to focus in on 4 examples of our third-party submissions because we've already gained some traction and seeing some robust activity from the applicants themselves in terms of claims amendments. What was so interesting about this is that all of the examples presented on your screen that have had their claims amended were actually done by the applicant themselves without any direction from the USPTO. So the applicants are recognizing that they are trying to take information from the public domain and are actually self-editing in order to make sure that their applications have a greater chance of success. So our first example is the application that is produced by Camtech. The reason why we went after this particular application is that the claims were very broad and encompassed well-established information that's already in the public domain. There was no data that supported the scope of these claims, and it's also a part of a series of psychedelics-focused patent applications filed by this company. And if granted as is, this application would have had a significant impact in psychedelic research and therapeutic spaces. So we were able to assemble prior art that was able to take down the 18 claims within this application, a total of 18 references overall. And you can see that we were able to assemble a broad cross-section of prior art for this submission, ranging from books to peer-reviewed journal articles, other patent documents, and even filings that were on public web forums, all of which were accepted by the USPTO. And within a month of us filing this submission, the applicant took it upon themselves to cancel all original 18 claims and replace them with 7 new ones that were far narrower in scope. And at first, we weren't particularly looking forward to saying that this was because of our third-party submission per se. However, the CEO of Camtech actually did that for us in saying that they just recently had a third-party submission against one of their cases, and they were something that he found very helpful. So not only are we putting this prior art in front of the examiners themselves, but we're also allowing innovators the chance to recognize that they may be overstepping the bounds of the public domain and then self-editing in order to ensure that they are standing within the bounds of innovation that they're presenting. So our next example is the filing that we made against Yale University, as well as the US Department of Veterans Affairs. So the reason why we had selected this particular application is that, again, claims were very broad in nature and established and encompassed well-established information. There was also no data that supported the breadth of the claims overall. And if granted as is, the application wouldn't have had a significant impact to research and development. So as you can see, compared to the original claim, which is a method of treating headache disorders, method comprising administering an effective amount of a composition comprising a psychedelic to an individual in need thereof in treating the headache disorder. The amended claim is much more specific comparatively. So they're not only identifying a specific psychedelic compound, in this case psilocybin, but also a dosage range, the specific type of headache disorders that they're hoping to address, as well as a dose regimen. So what's interesting is that for the 29 claims that were originally within this application, we submitted 5 pieces of prior art, and chances are it will also likely be able to address this amended claim as well. But we are waiting for word back from the USPTO to see how they're going to weigh that prior art in their decisions. And with that, I'm actually going to pass this over to Dave Casimir.
Well, my name is Dave Casimir. I'm one of the founders of the Casimir Jones law firm. I'm a biochemist by training originally. I do a full range of patent practice, from patent prosecution, due diligence reviews, litigation, and the like. And so our third impact example here is one of the Compass Pathways patent applications that actually received quite a bit of media attention. This particular patent application broadly claimed psychedelics for the treatment of depression. It had dependent claims in it that were focused on set and setting considerations. This has been featured in a Vice documentary and in any number of articles that are out there in the press. We filed a third-party submission against this application as well. Just for example, the original broad claim was essentially treating depression with psilocybin. That had been happening already in a clinical trial that had been occurring at Johns Hopkins and had been published by Johns Hopkins well before the original priority date of this application. And in this particular case, whether it was because of us or not, we're not sure, but shortly after filing of our third-party submission, the claims were all amended to make them much narrower. The original independent claim that broadly claimed depression treatment with psilocybin was changed to treatment using a very specific crystalline form of psilocybin that is a matter of its own dispute in some other matters, but the way that's been reviewed in those other matters, it looks like this is going to be a very narrow interpretation of a specific crystal form of this drug. we can get into it maybe in the Q&A session. There's a question about whether it actually is describing something that exists or not in reality. But for the purposes of this patent application, it takes it from a broad claim to all psilocybin for treating a broad category of disease to a very specific compound that, to my knowledge, no one else is using and perhaps not even Compass is using. Next slide, please. There we go. Some of the claims that I think caught a lot of the media attention were some of their dependent claims on set and setting, claims to soft furniture, muted colors in the room where the therapy is happening. And the good news on this front, next slide, please, is in the amendment filed after our submission, all of those claims were canceled. So as it stands now, it's a significantly narrower patent application with what I would say are much less controversial patent claims. Next slide, please. Our last example for the day is an interesting one, and it's slightly different in the sense that the impact here is yet to be determined, but we have essentially two patent applications that were filed by the University of Basel. One of them was filed as a Track 1 accelerated patent application, and it's actually issued as a patent. The second is a pending application that we were able to spot before it underwent review, and we were able to file a third-party submission. So on this slide, we're seeing side-by-side claims that were in those two cases. On the right-hand side, we see the issued claim, which is a little bit narrower in scope, still too broad, and actually the subject matter of the prior art. So in our view, this claim is not valid as issued. Because it was a Track 1 application, it issued before it published. And so we were not in a position to catch it and submit a third-party observation. However, its sister case, which is on the left here, again, a very broad claim, broader yet, we were able to catch. And actually, we submitted our third-party submission on the pending application before the first one issued. The dates are here. We submitted our third-party submission on the pending case on April 14th of this year. And the notice of allowance on the issued patent was received by the applicant on April 20th of 2022. And interestingly, they did not submit in an information disclosure statement to the patent examiner or to the patent office the information they had received from the third-party submission. Whether that was done intentionally or not, who knows? We'd have to ask them. But that does raise some interesting questions if they try to enforce the issued patent about whether they made a choice not to submit those references, which could raise questions. I'm sure any challenger in that case will raise questions about potential inequitable conduct for not submitting those references. So there's a certain benefit to filing Track 1 applications and preventing third parties from commenting. However, if information gets out there and it's not submitted, it does put those claims, at least from a diligence standpoint, at risk, which is kind of interesting in this case. We've yet to get a review on the pending application to see how the examiner responds to it. We'll see how that looks in the future. Next slide, please. And just sort of wrapping up here, overly broad patents not only have a negative impact potentially on others, but on the applicants themselves. And I think some of the things we're seeing here with some of the examples and the impact we're having is applicants realizing that. In extreme cases, you filed a patent application and spent money that you shouldn't have spent because you've filed on something that has nothing patentable about it. And it would certainly be good to know that ahead of time, but also just in terms of managing claim scope to be more effective about costs in prosecuting those claims. When one thinks about filing international patent applications where the costs can run into the hundreds of thousands to millions of dollars, being smart about what's patentable and what's not patentable can be very important. And then in this field in particular, where there's a lot of focus and attention by interested parties out there, and a lot of these patent applications get media attention, there's an optics component that might not be as intense as it is in some other fields. So I think there's a lot that applicants ought to consider when filing broad patent applications in this space. And the Porta Sophia tool gives them an opportunity to be smarter about how they're approaching things. Next slide, please. And then just kind of wrapping up, we are a nonprofit organization, citing here a number of our supporters. financially or by volunteering resources, human resources and other resources. If anyone here is interested in learning more about us or getting involved, just reach out to any of us or click the link on the website, and we'd be happy to have as many people as possible participate. And we've got a link here to the site and a QR code to help get to that information if you are interested. But I'll wrap things up there and see if we have some questions for anyone in the group here.
Awesome. Yeah, thank you very much for that great presentation. I see Burgundy, you have your hand up. Do you have a question?
Yeah, so you raised an important issue. So if a patent is granted before a third-party submission happens, the way that I view it is kind of the challenges between the finances and the resources to challenge a patent. What is available? And this is not my wheelhouse, but it's just something where I even know in my work, like, you can't unring a bell. It can be very expensive and really chill an individual's ability. I mean, they just can't afford it. They don't have the time, the money, or the resources. So what are your thoughts on that? Or, are there any solutions as to how that can be addressed going forward?
Yeah, there's sort of several options. So the least expensive is kind of the PR or sort of public shaming in a sense, or public outing of the prior art. To a certain extent, once the information's out there that a patent is invalid, and if it's not controversial, if it's based on very clear evidence, there is an ethical obligation for anyone filing a lawsuit not to file a frivolous lawsuit. So if the answer is so clear that no reasonable person could file a lawsuit, just sort of outing the information publicly, even after a patent's issued, will in theory cause the patent holder to not assert it. That being said, it can still have sort of suppression on the field, right? Investors may still be worried about it and forego investments. So then we look at some of the more expensive routes. There's really three primary routes in the United States, and I'll cover them from most expensive to least expensive. So the most expensive is you just fight it out in a district court battle. Costs there really vary, but if you're getting in front of a jury at the end of the day to deem a patent invalid, several $1 million, probably on the low end, very, very expensive, very time consuming, not something that everyone can do. Thankfully, with the new patent rule changes that came into place with the AIA system, passed in 2011, implemented in 2013, there's a fairly robust reexamination process in the patent office where, especially if it's prior art based, you're almost have free reign to bring a complete argument, no matter when you bring that argument. One of the regimes you can attack on all grounds of patentability, enablement, written description, statutory subject matter, but there's a window of time in which you have to be able to do that after the patent issues. 9 months after that time goes by, you can't use that system anymore. But there is a system available at any time where prior art can be used. Now, the type of prior art is more limited in that context. So if you're using unusual prior art, it might become problematic. But still, that's a process that is actually more effective than district court litigation statistically in knocking out bad patents. When you look at the statistics, somewhere between 60 and 70% of patents in their entirety are knocked out when challenged via that re-exam route. Of the remainder, about half of them have their claims amended. So a very small amount sort of emerged from that process fully intact. It is litigation light. The opponent gets to do some level of discovery, bring in expert testimony, and along with that, it's somewhat expensive. Costs vary. It can be done maybe efficiently for about $200,000 up to maybe $1 million for a more aggressively litigated case. So a factor less expensive than district court litigation, but still expensive, but very effective. The least expensive route, and I think one that's generally available to almost everyone, is an old re-examination process that existed under the old rules that's still available, called ex parte re-examination. Here, a challenger submits prior art to the patent office and makes their arguments, and then steps away from the process. So unlike this more robust regime that came into place with the legal change, you're out of it after you submit your original document. But if you've got a very strong case, that patent will get knocked out. And the cost of doing that, there is cost to sort of writing it up and doing it well. But if you find someone to do that without charging, the actual government fees are relatively small. 4-figure $1,000 range costs, not 5-figure.
Great. Do we have any other questions? I had a couple questions myself. One question, I know you noted that at least that one MindMed patent was sort of shielded behind track 1. I guess the first part is, do you know if any companies, I think I've seen many filing numerous track 1s. Do you know if that's been taking sort of affirmatively as a strategy to avoid sort of what you're doing? And then I guess if it is, like, is there any way around it? And of course you can't speak for what people are, what's going on, but do you have any sense to like whether just generally that can be a strategy? And if it is, like, what are your options? I mean, I guess you just laid out the ones post grant, but is there any sort of other way of trying to handle that situation?
Yeah, so I'm suspicious about whether people are using it as an approach to avoid interference by us or others. It seems like maybe there's a little bit more activity in the track 1 space in this field than other fields, without otherwise a particular need to get these patents granted quickly, right? There's not infringers out there, generally speaking, especially for the therapeutically directed ones, because no one's got FDA approvals at this point. So I'm at least suspicious about it. One of the approaches we're taking to deal with it is we've started doing observations at the international stage. So it's not that someone couldn't avoid this with a track 1 by filing very early in the US. At the same time they filed an international application that would still in theory get granted before the international version published. But what we're generally seeing, especially with international applicants, non-US applicants, is they are filing through the PCT treaty route and then entering the US with a track 1. In that sense, there is a chance to get that prior art in at the international stage. Whether the US examiner, for example, will pick that up and review it as carefully as they would a third-party observation isn't as clear, but it will generally make it into the record in the US. If the applicant is sort of doing their job of submitting that through an information disclosure statement, which most people do by practice. If they don't, I'd say they're at risk for an inequitable conduct charge later on. It's a mechanism to at least deal with some of the track 1 filings, but if someone was being aggressive about it, they could get through and avoid third-party observations with a track 1 filing.
One other kind of question I had was, I know you have your own system for putting these in tiers, but do you ever take suggestions from others, or have you worked with others, or is that something you'd consider? I know, at least what I've heard, sort of through the grapevine, of course, different parties are going to be frustrated with different applications, but is there ever an opportunity for somebody to sort of partner with you if maybe they don't have their own attorneys, or they have an interest but they don't have the resources to do something like this themselves? Or are you sort of a closed system, you sort of you figure out what you want to combat and that's what you go after?
We're very open. We've had conversations with people. So if someone's got something they want to challenge, but they don't feel like they can do it themselves, we're happy to consider that on a number of grounds, at least in terms of what we're doing with our 2-tier system. We'll certainly get the prior art reviewed if it seems like it's a relevant patent application or patent and get it into our database. We'll consider it for a third-party submission, but it does have to meet our criteria. We really wanted to make this a fair system, as unbiased as possible. So we try to be as objective as possible in our criteria. Now, obviously, you saw the criteria, and some of them can't be completely objective, but we try to stay as objective as possible. But if someone finds something that we didn't find that deserves that level of attention, we will give it that level of attention. We are also certainly willing to consider additional routes for attacking overly broad applications or even issued patents, particularly if people are willing to fund those activities, but maybe don't want to do it themselves. Now with sort of the IPR, PGR, the sort of re-exams that are the very active ones, you do have to declare yourself if you're a party, so there's no hiding in those, but the ex parte re-exams can be done anonymously. And so we, in the right circumstances, assuming we had bandwidth and it seemed to fit our our sort of narrative and our standards, we would be happy to cooperate with third parties to challenge patents and patent applications that need challenging.
Great. Well, good to hear that. Other audience questions? I think I see one hand. Was it Burgundy? Hi.
It's me again. I feel I'll pipe up. If somebody
No, please.
does have a burning question, please, I don't want to monopolize, but I hope these questions are helpful to everyone. So when it comes to the compass, that crystalline structure, and again, this isn't my superpower, so maybe just like a really good science communicator to explain, why is that crystalline structure not considered a product of nature? Did they actually modify it? I just got really confused as to what they were saying was unique. Because yeah, and I'm just confused. So if you could shed any light on that, that would be
Sure. I'll give you the story as I think they would tell it, and then I'll give you the story as I would tell it, because they're two different stories. So the story they would tell it, and that's told in their patent application, is that they've generated what's called a new crystalline polymorph. So for those on the call who aren't familiar with that term, a polymorph is essentially the shape of the crystal structure that you can form. So like, if you think about like table salt, it's if you've seen sort of images of what that looks like microscopically, it's like a cube, like a dice. But you can actually, for a lot of different compounds, generate different shapes, triangles, rhombuses shaped things, you can get these, and some of those have different properties. They different bioavailability, different stability, different activity in theory. I mean, once they dissolve, it's the same compound at the end of the day, but at least from a formulation standpoint, it can make a difference. And so there's a lot of research in the pharmacy space in general for new polymorphs that might have some sort of new interesting property. And so Compass has taken the position that they've identified a new polymorph, which would be a non-naturally occurring polymorph in theory. Now, that being said, there was a peer-reviewed publication that came out in fall that called into question the science behind that polymorph. And that peer-reviewed publication used a lot of different sort of cutting-edge scanning technologies to analyze the crystal structure. And there were two main conclusions from that paper. The first is that it wasn't actually a new polymorph, but essentially a contaminated sample of two known polymorphs. The way Compass had identified it is they used a particular analytical technique that gave sort of peaks, and they defined it based on a series of peaks. So when you saw their claim, you saw the claim sort of claimed it by a particular peak profile using this analytical technique. That peak profile fits the situation of being a contaminated sample. So conclusion one was it didn't seem to be actually a new polymorph, but just a contaminated sample of two known polymorphs. The second conclusion it reached is that some of the prior art samples that were out there, actual physical samples from the 1970s, 1980s, and later, and the group that did the paper actually got their hands on old historic physical samples and had them tested, had extremely similar combinations of polymorphs and gave not an identical, but extremely similar pattern. So there's arguments there that it's actually not claiming a thing that's real, as well as the fact that if it were real, if one attempted to claim it too broadly, there is a situation it would be claiming something found in nature, but also that it would read on the prior art. So Compass is really kind of pinned down to this specific way they've characterized it. That was challenged in a post-grant review process. The claims were upheld, and when you read the opinion, essentially what the judges said was, well, you're calling this polymorph A. We're seeing arguments that polymorph A isn't what you say it is, but as a patent holder, you get to be your own lexicographer. You said it's this, we're going to treat it as this. When you narrowly define it by these peaks, it looks like it's new. You can have that, whatever it is. We don't care what it is. You can have that. So it looks like that's what they've got. I'll leave it to the scientific community to fight about what exactly that is, but it's not broad.
Thank you so much for clarifying that. I'm crystal clear on, oh no, well, I guess. Right. Thank you.
Yeah, thank you, David, and thank you, Tom and Shaheen and Cece. I know we're pushing up on our hour, so unless there is another burning question, maybe we can kind of wrap it up here. But I'm sure you can get a hold of all of these folks from the information that's still on the screen here. I'm sure they would invite you to do that. And other than that, so I did put the poll for the next meeting in the chat. If you haven't got it, it's also, I think, in the last email.